Section 12. Legal methods of contract discharge. Contract law in today's market. Understanding the legal methods of ending a contract. In the previous section, we explored the concept of contract discharge and examined several common reasons why contracts may come to an end. While some contracts are discharged through successful completion of the agreement, many real estate transactions involve circumstances where the contract must be terminated, modified, or transferred through recognized legal mechanisms. Contract law provides several formal methods for ending or altering contractual obligations. These legal methods allow parties to adjust agreements when circumstances change while still protecting the legal rights of everyone involved. In real estate practice, understanding these methods is important because transactions often involve changing timelines, financing challenges, inspection issues, and other complications that may require modifications or termination of the original agreement. For real estate professionals, recognizing the proper method of contract discharge helps ensure that transactions are handled legally and ethically. Proper documentation and communication are essential when contracts are modified or terminated to prevent misunderstandings and protect the parties involved. Objective impossibility of performance. One legal method of contract discharge occurs when performance becomes objectively impossible. Objective impossibility means that no party could reasonably perform the contractual obligation due to circumstances beyond their control. This doctrine typically applies when the subject matter of the contract no longer exists, or when an unforeseen event makes performance physically or legally impossible. For example, if a property scheduled to be sold is destroyed by a natural disaster before closing occurs, the seller may no longer be able to transfer the property as originally agreed. Because the property no longer exists in its original condition, the contract may be discharged due to impossibility of performance. Courts evaluate these situations carefully to determine whether the event truly made performance impossible, or whether the difficulty could have been anticipated and addressed within the contract terms. Contract cancellation. Cancellation occurs when one or both parties exercise a contractual right to terminate the agreement before completion. Many real estate contracts contain contingency clauses that allow one party to cancel the agreement under certain circumstances. For example, a buyer may have the right to cancel the contract if the property inspection reveals significant structural problems or if the buyer is unable to secure financing within the agreed timeframe. These cancellation rights are typically outlined in the purchase agreement and must be exercised according to the procedures specified in the contract. When cancellation occurs according to the terms of the contract, the parties are released from their obligations without being considered in breach of the agreement. Proper documentation of the cancellation is essential to avoid disputes. Rescission. Rescission is a legal remedy that cancels a contract and attempts to restore the parties to their original positions before the agreement was formed. Unlike cancellation, which often occurs based on contractual contingencies, rescission typically arises when there is a legal defect in the contract itself. Rescission may occur in situations involving fraud, misrepresentation, mutual mistake, or undue influence. When rescission is granted, the contract is treated as though it never existed, and any benefits exchanged between the parties are returned. For example, if a buyer discovers that a seller intentionally concealed serious structural defects in the property, the buyer may seek rescission of the contract and request the return of any funds paid during the transaction process. Assignment of contractual rights. Contracts may also be discharged or modified through assignment, which involves transferring contractual rights from one party to another. In real estate transactions, assignment often occurs when a buyer assigns their contractual interest in a purchase agreement to another buyer before closing occurs. For example, an investor who enters into a purchase contract for a property may later assign that contract to another investor who agrees to complete the purchase. The original buyer transfers their rights under the contract, allowing the new buyer to step into the transaction. While assignments are permitted in many situations, some contracts contain provisions that restrict or prohibit assignment without the consent of the other party. Real estate professionals should carefully review contract terms before advising clients on assignment possibilities. Novation and substitution of parties. While assignment transfers contractual rights, novation involves replacing one of the parties in the contract with a new party who assumes both the rights and obligations of the original agreement. In a novation, all parties involved, including the original party, the new party, and the other contracting party, must agree to the substitution. Once the novation occurs, the original party is released from the contractual obligations, and the new party becomes responsible for performing under the contract. For example, if a buyer under a purchase contract transfers their position to another buyer and the seller agrees to the substitution, the new buyer assumes the contractual obligations and the original buyer is released from liability. Substantial performance. In some situations, a party may complete most, but not all, of the contractual obligations required under the agreement. When the remaining obligations are minor and do not significantly affect the purpose of the contract, courts may determine that substantial performance has occurred. Substantial performance means that the essential purpose of the contract has been fulfilled, even though minor details remain incomplete. Courts may still require the party who substantially performed to correct minor deficiencies or compensate the other party for small losses resulting from the incomplete performance. For example, if a construction contract requires several improvements to be completed before a property sale and nearly all the work has been finished except for minor cosmetic details, the court may determine that substantial performance has occurred. Partial performance. Partial performance occurs when a party completes only a portion of the contractual obligations but does not fully perform the agreement. Unlike substantial performance, partial performance may not be sufficient to satisfy the contract's requirements. However, courts sometimes recognize partial performance when fairness requires acknowledging the efforts already made by one of the parties. In certain circumstances, partial performance may provide evidence that an agreement existed, particularly in disputes involving oral contracts. In real estate transactions, partial performance may occur when a buyer begins preparing for a property transfer or invests money in the property before the transaction is finalized. Satisfaction of contract terms. A contract may also be discharged through satisfaction, which occurs when the parties complete the obligations described in the agreement and accept the results of that performance. In real estate transactions, satisfaction often occurs at closing, when the buyer provides the purchase funds, the seller transfers ownership, and all contractual conditions have been fulfilled. At this point, the agreement has achieved its intended purpose, and the contract is discharged. The closing process typically involves multiple parties, including escrow officers, title companies, lenders, and real estate professionals, all working together to ensure that the contract terms have been satisfied. Contract modification and alteration contracts may also be discharged or modified through contract modification, which occurs when the parties agree to change one or more terms of the original agreement. Modifications must generally be documented in writing and signed by all parties to ensure that the new terms are enforceable. For example, the parties may agree to extend the closing date if the buyer needs additional time to secure financing. This change must typically be documented through a written amendment or addendum to the original contract. Improper alterations to contracts can create serious legal problems. If a document is altered without the consent of all parties, the modification may be considered invalid and may lead to disputes about the enforceability of the agreement. Proper documentation and communication are essential whenever contract terms are modified. Online discussion 1. Question: why must contract modifications typically be documented in writing? Answer: written documentation ensures that all parties clearly understand the new terms of the agreement and prevents disputes about whether the modification was actually agreed upon. Written amendments also provide evidence of the parties' intent if the contract is later reviewed in court. 2. Question: how does novation differ from assignment in a real estate contract? Answer: assignment transfers contractual rights to another party, while the original party may still remain responsible for the contract. Novation replaces the original party entirely, transferring both rights and obligations to the new party with the consent of all parties involved. 3. Question: why might a court recognize substantial performance instead of requiring perfect performance? Answer: courts recognize substantial performance when the essential purpose of the contract has been fulfilled and the remaining deficiencies are minor. This approach prevents one party from unfairly avoiding contractual obligations over small or insignificant issues.